welcome to the Appellate Division First Department. I will begin with the call of the calendar. Please remember, we are familiar with your cases, your briefs, the record. Please ask for the time that you need, not the time that you want. Understand that the clock is for you, not for us, so that if we have more questions, we can go beyond the light, okay? All right. That being said, I think I left my glasses. All right, that'll be fun. Exactly. I'll make two.
You sure?
Yeah.
Reading fast.
Let's see. Okay, that works. Yeah. Call my chambers and have my staff bring down my glasses, because one of us needs glasses. All right. People v. Corin Bailey. Okay. Okay. 6 and 2 and 7. Cordero versus Kaczynski. Submitted. X Chen. Okay, how much time would you like? Okay, so as I said earlier, I'm going to give you 4 minutes, and if the court has additional questions, we will continue asking questions, okay? All right. I know I'm messing up the pronunciation of this one, so bear with me. Srivastava versus Rosetta Holding.
Your Honor, it's Richard Rosberg. I'm sorry. Your Honor, plaintiff, appellate, respondent, Srivastava. Can we have 8 and 3?
Okay, is there a respondent?
There are 2 respondents. We have 6
Okay. Let's do 6 and 1 and 4 and 4. Remember, the time clock is for you, not for us. If we have more questions, we'll keep going, okay? All right, Romano versus New York City Transit Authority, 5 appeals. They are submitted. People versus Saif Reed is submitted. People versus Stephen Cruz.
Good afternoon, Your Honor. Still around the appellate. We're reporting 8 and 2.
6 and 2 and 7. Phillips RS versus Ares Pharmaceuticals. Submitted. Lazar versus Moore. Okay. 3 and 3 and 6. Biggio versus Gooding is submitted. Ellen Bogan versus Matrisky.
Good afternoon, Your Honor. Benjamin Katz on behalf of the appellant, Michael Ellen Bogan. 4 and 2, please.
Okay. Respondent? Okay. 4 and 2 and 5. Otaji versus Gateway Security Guard is submitted. First case on the calendar is People versus Corin Bailey. You may proceed.
Thank you, Your Honor. Good afternoon. May it please the court. Taylor Poore with the Office of the Appellate Defender on behalf of Karan Bailey. Mr. Bailey only ever made one request for a new lawyer before his murder trial started, and the trial court should have taken that request seriously. Instead, the court denied the request summarily on the ground that jury selection had started.
Well, but isn't that correct? The request was made on the second day of jury selection.
Correct, Your Honor. I'm sorry, what was the question?
Why not before jury selection was commenced?
The court, I may be misunderstanding you, Your Honor, but the court denied the request on the grounds that jury selection had started, which it was not allowed to do. Once Mr. Bailey made a serious request for new counsel, the court was obligated to engage in inquiry, which it did not do. The court summarily denied.
Initially, the court did not make that inquiry, but didn't it subsequently make a more detailed inquiry and ask questions and elicit more details about the request, and then decide to deny it?
There was never any inquiry that gave Mr. Bailey a meaningful opportunity to be heard on the substance of his concerns, and the record is very clear on that. So I urge the court to focus on pages 88 to 93 of the voir dire transcript. Defense counsel says, my client wants a new lawyer. The judge says that application is denied. We already commenced jury selection. Mr. Bailey jumps in. The judge accuses him of trying to delay trial. He responds to refute that accusation, saying, my lawyer has been waiving my appearance. I haven't been produced. I've had this motion notarized for months. My lawyer refused to give it to you because he thought you'd deny it. So by the time the judge asks, what is your concern about him, it has already denied his motion. But what happens after that question is that the judge actually never gives Mr. Bailey a chance to give any specific details about his concerns. Mr. Bailey mentions his written motion, which the court completely dismisses, calling it boilerplate. So it's not on its substance.
It was blank.
And then the court, Mr. Bailey offers to give specific details. He offers in two separate ways to flesh out.
You recognize that a written motion, that's not how a court considers a written motion. If a written motion has all of the salient, important facts missing from the written document, attempting to amend that motion orally is not the way we do things, especially in the second day of trial, correct?
Judge, in cases where a defendant makes a...
Is that normal?
Is it normal to...
Accepting a boilerplate blank motion in the middle of trial and permitting a defendant to amend that motion, a motion that his defense counsel has not adopted, in the middle of trial? Is that something that is typically done?
Absolutely, Your Honor. In cases where a defendant is seriously requesting new counsel, even if it's after jury selection has started, and our brief cites many cases where this has happened, the judge is required to engage in an inquiry that it gives the judge enough information to know the actual substance of the complaint, and that did not happen here. After the judge dismissed the written motion, Mr. Bailey repeatedly offered, first of all, if the items in the boilerplate motion, even if you're calling them boilerplate, if they're true.
No, you called them boilerplate.
Sorry, I'm assuming I'm Mr. Bailey.
This always happens. Attorneys cast upon me statements they make and then make them my statements. I want to be very clear. You said that, not me.
Absolutely, Judge. I'm sorry. I was trying to put myself in the role of Mr. Bailey talking to the trial court, and I was absolutely not clear about that. But then at the end of this colloquy, Mr. Bailey says repeatedly, I could specify, I can specify. The judge talks right over him and brings in the jury. That is not a meaningful opportunity to express his concerns about his lawyer. And the court forced Mr. Bailey to go to his trial on his murder charges with a lawyer that he could not effectively communicate with and who had clearly given up.
What he said, I thought what he said was, he hasn't spent enough time with me. This is the first time I've talked to him in months, that kind of thing.
Absolutely, all of which constitutes a breakdown in communications and an inability to communicate productively. But the court did make a lot of assumptions about what Mr. Bailey's reasons were for requesting a new lawyer. None of those came from Mr. Bailey. Again, Judge, Your Honors, to read this record to say that the court gave Mr. Bailey a meaningful opportunity to be heard on his request for a new lawyer would be to misread this record. The court also erred when it refused to grant jury instructions on extreme emotional disturbance. Jurors at Mr. Bailey's trial should have been permitted to decide whether, even if he did intend to kill Mr. Edwards, he was suffering from an extreme...
I thought that the court denied that because there was, what was there in the record to indicate that he was, other than him saying that he was suffering from EED?
So it was Mr. Bailey's testimony. He testified extensively that shortly before the shooting, he had experienced a traumatic event.
this was a robbery that took place prior to the day in question. It
Absolutely.
wasn't even on the same day, was it?
Correct, and that is not what is required for EED. The cases are very clear. I'm sorry.
EED requires that you are under the heat of that, no?
No, it does not, Your Honor. That is justification. Extreme emotional disturbance contemplates, may I just quickly finish my answer?
Yes, you may, and I, of course, am quite familiar with this, having practiced in this area and written many a decision on this issue, but please proceed.
I can give Your Honor the specific sites when I come back for my rebuttal, but EED, unlike justification, contemplates that there may be a passage of time between the triggering event and the event that is caused.
How much time was that in this case?
I think it was about a week. I can try to,
So he's suffering from extreme emotional disturbance from a alleged robbery that took place by the victim here,
and his accomplice,
right, a week earlier.
around that, I believe, Your Honor, yes.
So that would support and justify him skating on his skateboard down the street, jumping off and shooting this person in the face.
EED, oh, I'm sorry, Your Honor. I didn't mean to interrupt you. Could I respond to that as well?
Yes, please.
EED does not require that the actions taken in the emotional disturbance be reasonable. That's, again, a difference from justification. All it requires is that based on the reality or the circumstances as the person suffering from EED believed them to be, those actions were reasonable,
Wait,
not
are you,
objectively
counsel, are you
reasonable.
saying that it's all subjective?
Yeah, so EED contains a
I don't,
requirement that the...
but that, for sure, that's not correct.
So there is an objective prong,
Right.
which is that...
And
the-
do you have any cases where you can show someone a week later has a legitimate EED defense?
I can refer to my brief, and
I know, I looked at the cases in your brief. None of them go, I mean, that is quite a while
So
in between the event and the EED. So, and I didn't see a single case that would support a finding of EED a week later.
I believe in DeLuca, there is at least a few days that go by. I can refer to my brief for more examples, but again, EED is very different from justification because it's not a complete defense. And it involves, it contemplates that there's a passage of time, and it contemplates that the actions that the person took were absolutely not objectively reasonable, but were subject to what the circumstances where they believed them to be. And if I can.
You'll have time on rebuttal. Okay. Counsel, we'll hear you now. You may proceed.
Good afternoon. May it please the court. Megan McLaughlin for the people. I would like to address counsel's arguments as to the substitution of counsel claim, but
I think the more pressing question is this issue of the EED. Why don't you address that first?
Yes, Your Honor. As Your Honor already referenced, a defendant, it is necessary for the defendant to be under the throes of whatever emotional disturbance that they are claiming caused the feelings that led to the crime.
So outside of the fact that this defendant claims to have been robbed by this victim a week earlier, is there any other evidence to support, other than that fact by itself, that he was suffering from extreme emotional disturbance?
No, Your Honor, and as this court has pointed out, there is absolutely an objective element to this defense, which would be that not only does the defendant need to show that he acted under the influence of an extreme emotional disturbance, that there needs to be a reasonable explanation or excuse for those feelings to be occurring. The defendant did testify that he had been robbed previously by the victim that he ended up killing. However, the defendant's own testimony as to what those feelings were, as the trial court pointed out, seemed to be tailored to the language of an EED offense. Other than that, the evidence in the case shows that this defendant was working on his relationship with his girlfriend directly before the crime was committed. He received a phone call. He left the house with a loaded gun, with seemingly all of his faculties. He snuck up behind the victim. He scared the victim by shooting once. The victim fell. The victim was lying face up on the sidewalk still, and the defendant pointed the gun at his eye and shot him in the face. These are not the actions, and there's case law to support this, these are not the actions of somebody who is suffering under the throes of an emotional disturbance. This is somebody who is aware of what he is doing, and then subsequently after the crime, displaying consciousness of guilt by attempting to shield himself from responsibility. Now, to move on, unless you're...
Explain that further. What do you mean by that? What actions did the defendant take that would support a consciousness of guilt argument?
Immediately upon leaving the scene of the crime, he returned to his sister's apartment, he changed his clothing, and he left the weapon as well as his mode of transportation, which had been his skateboard, at his sister's home. He then went to his friend's house and proceeded to change his clothing another time, wearing clothing that his girlfriend and the friend testified were not typical choices of his.
And was there evidence of a visual nature at the friend's house?
Yes, Your Honor.
That would support a argument that this was not the affect of a person who is suffering from the throes of extreme emotional disturbance, having taken the law into his own hands and shooting somebody in the face. Is there any evidence about that?
Yes, Your Honor. The video evidence, the surveillance video outside of his friend's apartment that he went to shows his friend greeting him at the door and both of them smiling and laughing and walking inside very casually. This did not appear to be a person who was, again, suffering from some emotional disturbance.
And how long after the shooting was that video?
Within 1 hour.
Thank you.
Now, to address counsel's arguments about the substitution of counsel, as this court has pointed out, this was on the second day of jury selection and the third consecutive day that this defendant was present in court and communicating with the judge. Of his own accord, he was discussing with the judge various different things in these 3 days leading up to his ultimate request, which that morning he had missed the early bus to come into court, and then shortly after he arrived, requested a substitution of counsel. Now, as this court has already discussed, at first the judge did deny the motion, but very shortly after that, once the defendant indicated that he would like to discuss it, the court asked him the open-ended question of, what are your concerns about your counsel? So in response to that open-ended question, defendant had every opportunity to discuss his issues with his counsel. Instead, he, as this court noted, handed up a blank motion with no details and no examples of any misgivings he had with his counsel. The judge then made a record of how he, in his dealings with, at the proceedings with defendant, had noticed that defendant was engaging in various dilatory tactics. He believes this might be one, unless the defendant had any other reasons, and according to the motion that he handed up in response to the court question, he did not. So at that point, the judge cut off the discussion that after he found that there was no good cause by defendant showing that a substitution of counsel was warranted. If your honors have any other questions about the other claims of the brief, the ineffective assistance of counsel.
Do you wish to be heard on the consecutive sentences?
Yes, Your Honor, just that it's the people's position that if this court were to amend the sentence, the possession with intent count should run concurrently with the murder count, but the simple possession count should remain consecutive consistent with the judge's intentions.
One question, when and is there any evidence in the record of when the gun was acquired, how the gun was acquired, anything like that?
The defendant's testimony was that he had acquired the gun from a friend beforehand, at some point before, I believe it was a number of days before, but there was evidence by both the defendant and the people that the defendant had been at his sister's house, not his own house, with the loaded gun, and then proceeded to leave the house, walk on the sidewalk, with the loaded gun up until the moment that he shot the victim in the face.
Thank you.
Thank you, Your Honor.
So you have 2 minutes.
Thank you, Your Honor. I'd like to just refer the court to the cases cited. Regarding the extreme emotional disturbance instruction, I'd refer the court to the cases cited on pages 23 and 24 of the reply brief. Mr. Bailey did not need to present any psychiatric evidence in order to be entitled to the defense. People versus Pavone is the case distinguishing EED from the kind of heat of passion justification defense. DeLuca versus Lord gives more detail about the passage of time. And as far as the statute having both an objective and a subjective prong, it requires a reason for the mental disturbance, which does not rise to the level of mental illness, but not that the action that resulted be reasonable, and that's People versus Harris. Jurors could have absolutely rejected the EED instruction in the defense, but that was up to them, and the court should have given the instruction.
Counsel, can you address the sentencing issue here?
Absolutely.
Especially with respect to the gun and what evidence there is of when the defendant acquired the gun, et cetera.
There is no evidence other than the testimony that Mr. Bailey took the gun with him on his way to this shooting. So there's no evidence of possession or intent to acquire the gun for any other purpose than involvement in the shooting. So all of these convictions center around this shooting. And 25 years to life is ample punishment for this event. And if this court is inclined to remand, we'd ask that it be for a de novo resentencing so that Mr. Bailey can be represented by a lawyer who does actually effectively represent him. But in conclusion, I just have a few seconds left. These were extremely serious charges, and this was a complicated and difficult case. Mr. Bailey had the right to have at least one chance to be assigned a new lawyer with whom he could have tried to build a more productive relationship.
Is there any case that says that a defendant is entitled to one freebie change of counsel, which is what you're suggesting?
What I'm asking is, and what I'm arguing is that in serious cases where a client has absolutely no ability to communicate with his lawyer and makes a serious request, the court should take that request seriously. And I believe that under these circumstances, Mr. Bailey was entitled to a new lawyer, although all we're arguing is that the court should have inquired further.
Thank you.
Thank you.
Srivatsa versus Rosetta Holding.
You gave Chen 4 minutes.
Oh, I'm sorry. Sorry, before that case, Chen. I wasn't expecting. Chen, you'll be called next. My apologies, I wasn't expecting a call on this case.
Good afternoon, Your Honor.
You may proceed.
Sure. So Xia Haoxuan is Xu Chen's bail son. On February 5th, 2019, Xia Haoxuan got the diagnosis of UTI and abnormal.
It might be easier, since you're standing up there alone, to pull down the mask so we can hear you better,
Sure.
if you don't mind.
Never
If
mind.
you have a problem, you can put it back on, but I'm struggling to hear you.
I'm good to.
Okay, wonderful. Go ahead.
Okay, so Xia Haoxuan is Xu Chen's bail son. So on February 5th, 2019, Xia Haoxuan got the diagnosis of UTI and abnormal EKG in CTMD clinic. Dr. Gumans made the referral to cardiologist, urologist, and pediatrics. On February 7th, 2019, the radiologist made the recommendation of test VCUG based on the ultrasound test result. The one-time test VCUG was prescribed by the urologist Dr. Papas in Weill Cornell Hospital on March 1st, 2019, and the test VCUG was done in Weill Cornell Hospital on March 4th, 2019. After the test, Haoxuan urinated blood in the doctor's office. Within 2 weeks, Haoxuan still urinated cloudy. So on March 15, 2019, Xu Chen received a phone call from Dr. Papa's clinic request for a medical record review, and request for office visit. This kind of medical review usually happens after each time of the office visit, so it's not that normal to receive this kind of phone calls. But Xu Chen agreed with the office visit time and mentioned about for second opinion for the Haoxuan's urinate test results. So on March 15, 2019, both Xu Chen's family, Haoxuan, my parents, were all forced to hospital with ambulance when we were having dumpling soups at home at late night, around 8 p.m. In the name of medical record review, from March 15th to March 18th, 2019, all my family members were locked in the hospital room with securities changed every 8 hours. Also on March 15, 2019, both New Jersey and New York Child Protective Agency received a phone call at the same time. Haoxuan didn't enroll in school for educational neglect, intend to cause pandemic, even though they have already we have already updated our new addresses in the hospital system. They knew clearly we moved to New York. After locked my family for 3 days, they knew that my visa type didn't fit the educational neglect request. Then on March 18, 2019, the hospital filed a report to Family Court New York. They found a parent unknown child in the hospital and nationality unknown. On March 22, 2019, Haoxuan being taken away from the hospital in a late Friday night with only a text to me, "I have him." Haoxuan's name was changed in the system, and on April 9,
Ma'am, you have 1 minute left. It might be more useful if you tell us what you want us to do.
Okay, sure. So on April 9th, 2019, Xu Chen found out that the court order on file to keep Haoxuan in foster care is a blank one. So through the court system, ACS doesn't have court order to lock Haoxuan, and Haoxuan is being hostage in foster care and was suffered in being taken away in an illegal way. So Xu Chen filed a motion in request to dismiss the fake report-based alleges to Xu Chen release Haoxuan from non-kinship foster care and back to family members. Present Family Court Act 1017, 1061, 1062, 1028, and 1051 first say.
Okay, you have run out of time, but as I understand your request, you want the court to reconsider the court below's decision to remove the child from the family home, correct?
Yes, and also in request for the child to be
Returned.
to be returned with family members during the court proceeding as the law requests.
Okay, thank you so much. You have a wonderful day. We're out of time, okay?
Oh,
The
thanks.
court will consider your request.
Okay.
Don't forget your mask,
Oh,
okay? Thank you. Srivatsa versus Rosetta Holdings. You may proceed.
May it please the court, Richard Grossberger for plaintiff appellant Prasanna Srivatsa. This case and plaintiff's claims have absolutely nothing to do with membership in the company Rosetta Holdings LLC. Likewise, plaintiff's claims have absolutely nothing.
So counsel, as I understand it, it's, you're arguing essentially that equity interest and membership interests were conflated down below. In your complaint, do you make any allegations with respect to membership interest versus equity interest, anything like that?
No claim that plaintiff has brought involves membership, and he has never alleged that he was entitled to or promised membership in the company.
But where do you get the basis for claiming that he has an equity interest? And I think, maybe I'm wrong, what my colleague was asking is, do you make any reference to equity interest in your complaint?
Absolutely, Your Honor. The complaint and the affidavits that Mr. Srivatsa submitted to the court specifically said that he was promised an equity interest, in specific a 16.67 equity interest in the company Rosetta Holdings, and in exchange, he had to support the spin-out of Rosetta Holdings into GTS and commit himself to work exclusively for Rosetta. And there was never, in the part of the discussion that led to the equity contract, the equity agreement that happened in November 2019, all they discussed was equity interest. And this is all my client thought he was getting.
You keep saying that it's just equity, but didn't you say in the complaint that he signed an employment agreement pursuant to which non-party GTS Securities was prohibited from firing him as long as he remains a Rosetta member? So didn't you expressly make a reference there that you were claiming that he was a Rosetta member as opposed to having an equity interest?
That's a,
Isn't that inconsistent?
no, not at all, Your Honor. That's a letter that the parties entered into sometime after the equity agreement was formed in November 2019, when my client signed.
When you're saying equity agreement, you're not referring to the contribution agreement dated November 7th,
Absolutely
2019?
not. I'm referring to an equity agreement, an agreement in November 2019.
This is the oral agreement, correct?
The oral
Agreement in 2019 where my client was promised equity. Membership wasn't discussed. And so you're right, Your Honor, when my client saw that as he remains a member, he thought maybe he did become a member, but he never believed that he was contractually entitled to membership. He never believed that he was promised membership. And all his claims have to do with specifically equity. And this is reflected in the Rosetta LLC agreement, where and Delaware law for that matter, which distinguishes between equity and membership. One can be an equity holder, and it's not contingent on membership. Likewise, in the Rosetta LLC agreement, it has two rights. One, the rights of an equity holder. The second, the rights of a member, and they're different. And so my client has never made the claim that he's a member. Now,
So counsel, there is some inconsistency. So you say equity interest, oral agreement November 19.
Correct.
But subsequent documents, the summary of terms, the contribution agreement, essentially say the opposite, correct? That there is no enforceable agreement? Or is it your position that relates to a different kind of interest?
absolutely not. The lower court got it completely wrong, Your Honor, because she didn't distinguish between membership and equity. He was promised equity, not membership. And she looked at the...
Where in the complaint specifically do you use that term? What paragraph in the complaint do you specifically talk about having an equity interest as distinguished from a membership interest?
Well, we talk about it, for example, in 23 of the complaint, my client also submitted to...
What does it say? What's the language that you're referring to?
Defendants would hold a 16.67 interest.
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 Where do you refer
But in-
to an equity
Well-
interest? Because that just happens to correspond to the exact numbers being initially
You're-
discussed in the written agreement. So it seems a little coincidental. So my question is, where in the agreement, in the complaint, do you actually talk about your client having an equity interest rather than a membership interest?
Well, in paragraph 18 of his affidavit, firstly, it's mentioned in the complaint, all over the complaint. But in paragraph 18...
Well, my colleague asked you for specific...
I gave her...
Counsel, I'm still talking.
I'm sorry, Your Honor.
My colleague asked you for specific paragraphs where you say, you assert that your client has an equity interest, not just interest, equity interest, because that's your argument. So perhaps when you come back up, since you have about 14 seconds left, you might be able to answer that question.
Your Honor, thank you very much for that opportunity. I will say in paragraph 20 of his affidavit on the record side 422, he said that he was going to get, I'm sorry, on paragraph 18, he was going to get an equity stake of 16.67%. That's what he says that he was promised. You'll not see anywhere in the complaint where he says he was promised membership, and you will not see anywhere in the affidavit.
But what you just said was, that was in his affidavit.
Was an
Question was, where in the complaint is it asserted that he has an equity interest? And perhaps, as I said, your time is up, but when you return, you might be able to point us to which paragraphs in the actual complaint that say that, okay?
Sure, Your Honor. Thank you very
All
much.
right. Next up. And you have 6 minutes. Or 4 minutes, sorry.
Good afternoon. May it please the court, Philip Bowman on behalf of the Rosetta defendants. The appellant alleges that there was an oral agreement in which Mr. Gelman granted him a 16.67% equity interest in Rosetta. As the motion court correctly found, that claim is utterly refuted by a written agreement that the appellant signed in which he agreed that he was not a member of Rosetta and may never become.
Is there a distinction to be made between an equity interest and a membership interest? Because it's the point of the appellant is that the two interests were conflated.
Right. So now on appeal, the appellant has a different take on it. He says, "No, I wasn't given an interest. I was given a quote-unquote equity interest without membership."
So, counsel,
That's a new
let me just
concept that comes
interrupt
up
you,
on appeal.
please, and ask you specifically, is there the word equity interest as opposed to interest, which in most parlance would, particularly when you're talking about a membership agreement, would mean membership? Is there anywhere in the complaint where he says, I was never promised a membership interest, I was only promised equity in the LLC?
He says he was in paragraph, in his...
Is the word equity even in the complaint in that way?
I don't know. I actually don't know, Your Honor.
Was that your understanding of what he was saying?
No, the clear understanding was that he was alleging that he had an interest that included a membership interest, because he says in paragraph...
particularly because he signed a document that said, I can't be fired as long as I'm a member.
Right.
And this whole litigation commenced when he was fired, correct?
Right. So there were several things, right? He says in his affidavit, he says that he believed that he was a member, that he already was a member, as evidence that he's entitled to this equity, right? He says the record site for that is 425. He said in the same affidavit that the contribution agreement showed his quote ownership share percentage, and that the whole point of the contribution agreement was to discuss possible contributions by the owners. And it then goes to list those potential owners, showing his share of 16.67%, which he now says is
And
a coincidence.
was there ever a written agreement set down that reflected any interest, equity or membership?
There was never anything that was signed that promised him either a membership or an equity interest. There was the summary of terms, which is, I just want to give you the site for that.
I've looked at it.
Yeah, okay. The summary of terms talks about them as being one and the same, and
Right.
something that would happen in the future.
I guess part of the problem is that the summary of terms in the second sentence on page 1 says that it doesn't constitute any form of binding contract or
Right.
create any obligation. So I can understand where he might have been perhaps somewhat misled, although that second sentence of the agreement does say that of the summary of terms does state that, correct?
Right, and so that's our argument, that this still hadn't been, it was as Justice Schechter found.
Agreement
an
to
agreement
agree.
to agree. Exactly, Your Honor. We didn't address the fraud claim. Does the court have any questions about the fraud claim? I'll just quickly address
You
it.
have about 10 seconds, so roll.
The fundamental point is there's no allegation that at the time that he supposedly promised the equity interest, that he had no intent to fulfill that promise. Thank you very much.
You may proceed.
May it please the court, my name is Ted Poretz for Catton Eugene Rosenman, LLC. Your Honor, this is a malpractice claim, number 7 and 8, 8 being a breach of fiduciary duty claim, which isn't discussed anyplace in the record. But as an ordinary principle, privity is required in order for there to be a claim of malpractice. There is a concession, in fact, that there is no privity. There is no engagement letter. There was no request for personal advice. There was very little personal contact, if any at all. There were no invoices.
He was relying, the plaintiff was relying to some extent on several meetings that were held in the discussion phase, I guess, where you said, please, sent him an email, said, please join us, please come to talks. I mean, that seemed to be important to him. I'm not saying that was a retainer agreement.
And all of the other individual defendants got the same announcements. They were general, generic meetings of the kind that any law firm representing a startup company like this would hold with the people interested. What are the terms? Where will we be working? How much will we be paid? What's the bonus? Those are all standard things that say nothing at all about individual representation.
And what about paragraph 11 of the contribution agreement, which seemed to make it pretty clear that you were not representing the individuals?
Not just that it makes it pretty clear, Your Honor, it should end the inquiry on that. And it should also end the inquiry on the two narrow exceptions to the privity rule that counsel spends lots of time in his brief talking about. If he agrees that he was not represented by Catton, that Catton was not engaged to represent him, then it can't be that he had the reasonable belief that Catton was his attorney's, exception number 1, and it cannot be that Catton misled him, recognizing that he was under a misconception into believing that they did represent him. Paragraph 11 ought to end all of those inquiries. There's just nothing in the facts other than things that are generic that a law firm representing a startup would do for anybody that would suggest individual representation. Not even clear, frankly, what it is that he says Catton did wrong. If you look at the last page of his reply brief, he says, if I should prevail against Rosetta, then I don't really have a claim against Catton, except perhaps the cost of bringing the lawsuit. Malpractice is determined when you commit it, not depending on what another case results in, period, full stop. And he doesn't say, for example, that he ever asked Catton to review his so-called equity oral agreement. He doesn't say, I asked him if this was good enough. Will the appellate division of the First Department enforce this? Am I in trouble? Do I need something in writing? He doesn't say any of this. With all respect, this is a contrivance from the first moment, and it's a contrivance today. Nothing stopped him from engaging his own lawyer. Nothing made him sign the amended contribution agreement. And by the way, lest there be any suspicion at all that the amended contribution agreement was just slipped in at the last second, it's the same date as the transaction and joinder agreement, the TAJ that you'll find in the second volume of this, without which there'd be no deal. These were standard deal documents on the day of the closing. They enabled the closing to take place. They enabled Mr. Srivatsa to do what he wanted to do and join this enterprise, and that's it. Finally, you'll note that his theory of damages makes clear that he can't prove proximate cause or non-speculative damages. What Mr. Srivatsa says is that if he had known about all the things he now appeals about, he would have hired his own lawyer. What that lawyer would have advised him to do, that's a speculation. Whether he would have gotten a better deal, that's a speculation. What he says he would have done is he would have gone back to Barclays and said, how about you don't spin me out, let me come back, let me expand the business, pay me an awful lot more money. That's the dictionary definition of speculation, and on that I see my red light. Thank you, Your Honor.
Thank you. And you have 2 minutes, sir.
Your Honors, the LLC agreement defines what my client received. This is the Rosetta LLC agreement. It's on page 91 of the record, and it defines interest. It doesn't say equity interest, it says interest, and that's what my client understands. It doesn't matter whether it's called ownership interest or equity stake. He received an interest, which is different. It is starkly different from what the LLC describes as membership rights. There are membership rights and interest holder rights, and my client received an interest. And Your Honor, I have not been able to find, I believe it's in there, where it says equity interest. But in paragraph 28, we talk about an ownership interest. That's on record 69 in the complaint. In page 70, paragraph 32, it talks about an equity interest. In the affidavits which he submitted, which were joined with his complaint, it talks about 10% of our equity. That's on record 422, paragraph 20. The idea also, Your Honors, that this was an agreement to agree is simply not correct. Nothing in their agreement said that, firstly, they said at the meeting that they had reached agreement. They expressly stated that they had reached an agreement. There was nothing in the agreement or in their discussions that would lead one to believe that there were open terms that needed to be negotiated. There was nothing. And I just want to make one more
Counsel,
point.
may I just interrupt you for a second?
Sure.
Didn't your client say in his affidavit that when he because of the language from the employment agreement, I understood from that language that I was a member, not an equity owner, a member of Rosetta. Didn't he say that?
Yes, he did, but that's my point, Your Honor, is he
No,
never
but
had
you're
a
arguing-
claim based on membership and never thought he was contractually entitled or was promised membership. Approximately a year
That
later,
is not what that says. It says, because I signed that agreement, I thought I was a member of Rosetta.
Right, but he never, in the same affidavit, in the same complaint, he never mentioned membership because he was never promised membership. He just thought after the fact that he may have been made a member. That doesn't mean that he believes he's contractually entitled to membership or he was promised membership, and none of his claims allege that he was a member.
Thank you.
Thank you.
People versus Stephen Cruz. You may proceed.
Thank you, Your Honor. May it please the Court. Celia Brown from Cleary Gottlieb, appearing pro bono in association with the Office of the Appellate Defender for Stephen Cruz. Your Honors, in a case entirely revolving around Mr. Cruz's state of mind, the jury was prevented from hearing crucial non-hearsay evidence on this issue. Instead, they heard the prosecution incorrectly claim.
All right, I need to stop you. The proffered statement that you say is clearly non-hearsay was a statement about why the defendant was going back upstairs, correct?
That's correct, Your Honor.
And that statement was being offered not just because it was said, but because of the truth of the matter asserted, correct?
No, Your Honor.
No,
Your Honor, the statement was to reveal his state of mind in returning upstairs, and this is crucial in understanding his knowledge.
But why do we need to hear that he intended to go upstairs if the evidence clearly demonstrated that he went upstairs, right? So that even if the brother could not testify, my brother said he was going upstairs, or whatever else he was going to say, because the statement is not in the record, right?
That's correct, Your Honor.
Okay, so I can only, as the court, we can only assume, speculate about what that statement was. And so at best, I can assume that he would have said, my brother, after we got downstairs in the elevator, he changed his mind and went upstairs. He got back in the elevator and went upstairs. But we know he went upstairs, right? I mean, that fact was in evidence. Am I right?
That's true, Your Honor. And so what's important about this statement is that First, this court has what's necessary to decide. The specifics of the statement aren't important because trial counsel excluded this based on the proffer that Mr. Cruz had told him a non-criminal reason for returning upstairs. And this court, these New York courts have long recognized, including in burglary cases, that contemporaneous statements made by defendants of their state of mind or intent are not hearsay. So, for example, in Boiling, the court admitted a defendant's...
So the state of mind of I'm going upstairs? I'm trying to understand what the proffered statement, which we don't know what that statement was. I think that's a problem here. That nowhere in the record does defense state for the record what the statement was.
Your Honor, what defense counsel did state and what the trial court ruled on in determining, sorry, Your Honor, there was nothing in the record that indicated that this was not specific enough for the trial court to rule that it was hearsay.
And the problem we have is that this court is bound by the record. And the record is absent of what the actual statement was. That is critical here.
But Your Honor, regardless of what the statement said, while the details may have gone to the weight that the jury assigned it, it doesn't go to its admissibility because the point was that this was describing why Mr. Cruz returned upstairs.
I don't know. Without knowing what the statement was, how can I determine what you just said?
Because, Your Honor, regardless of what the statement was, and as we provided examples of...
If the defendant's statement was, bro, I'm going upstairs, if that's all he said, well, the fact that he got back on the elevator and the elevator went up tells us that. We don't need the hearsay statement to establish that fact, do we?
No, Your Honor, but this was proffered that it was a non-criminal reason, for a reason why
Counsel, what I just said is a non-criminal reason. That by itself is not enough.
Right? And
I'm going back upstairs, unless he said, I'm going back upstairs to the party because I forgot something. I don't know what he said.
And that's why counsel explained that this went to the reasoning why he went upstairs, which is what counsel explained. And just to briefly turn to the...
I'll just ask one follow-up question. Even if he said, which we don't know because we don't have it, I'm going upstairs because I left something at the party, I'm going back to the party, it still doesn't overcome the evidence in this that when he got to the wrong apartment and he was told he could not enter, he still entered and did whatever he did.
Sorry,
we already know from the record that he's saying he didn't mean to go there, he meant to be going back to the party. I mean, we know that.
Well, we don't know because the prosecution used the exclusion of this evidence to argue, to weaponize this and shift the burden and argue there was no testimony that he thought he was returning back to the party. And so this would have been important in showing his state of mind. And this was especially important, just to briefly turn to the statements that the prosecutor made, because the key issue was, what was his state of mind? Did he know that he was entering unlawfully? And just a quick clarification, Your Honor, nobody said anything until after he was already inside the apartment. But here, the prosecution...
Their testimony is that he went in and started punching her. There was not even a chance. He just went in and started punching the woman. That's the testimony that the jury heard. So there wasn't even a chance to say anything because he went in and punched her. That's not what you do at a party you're going to.
Your Honor, but this ignores the other evidence that that Mr. Cruz had spent the evening enjoying himself, celebrating at his friend's party without any...
So it would make absolutely no sense why he would return to the party, walk in the door, and punch the woman who opens the door in the face. That's the evidence.
Yes, and the evidence also does, but this court should consider the circumstances surrounding that, and also...
Which is what?
Which is that Mr. Cruz had not indicated any violence. He'd been celebrating at his friend's
party. He punched the woman in the face. A 60-year-old woman is at home, just gets back from work, opens the door to someone knocking, and opens the door, and this guy punches her in the face.
Your Honor,
That's the evidence.
Mr. Cruz is not contesting the seriousness of this offense. However, here, not only the evidence that the jury didn't hear, but that they were told explicitly by the prosecution over defense objection that the defense had conceded knowledge, regardless of, even looking at the evidence that Mr. Cruz entered and punched someone, that does not indicate that he knew that he was entering unlawfully, and that's because not only was this a person in the same
Because
line-
there are people who open their door and say, come on in, punch me in the face. I mean, I don't understand that argument.
Your Honor, because Mr. Cruz had been in the same line of apartments. He was in 16C, this was 7C, and that goes to knowledge.
All right, so
not
it's
necessarily
9
intent.
floors of a difference, and I could understand that he had had too much to drink and perhaps didn't realize he was on the wrong floor. The problem that you have with the fact pattern here is that according to the evidence, she opens the door and your client immediately punches her in the face.
Of course, Your Honor, on that point, there was conflicting evidence, including the 911 call where her son indicates that he had opened the door, someone rushed in, and he fought him out.
And he explains why he did that.
Yes, Your Honor, but
And the jury considered all of that. But that has nothing to do with the hearsay statement.
Your Honor, but to address the, separate from the hearsay statement, to address the issue of knowledge, which is separate from intent, the fact that the prosecution argued over defense objection that the defense had conceded that he knowingly entered unlawfully, because the defense conceded he did not have permission to enter. But given all the facts that Your Honor just pointed to, his intoxication, the fact that, as I just explained, that this was in the same line of apartments, and the confusion that he expressed after being pushed out, this is simply extraordinarily prejudicial for the prosecution to argue that. And with regard to the—
All right, I'll allow you to make your additional arguments on rebuttal, okay?
Thank you, Your Honor.
We've gone about 4 minutes above, but I'm going to give you your rebuttal time. You may proceed, counsel.
May it please the court, Molly Morgan on behalf of respondent. As the panel has pointed out, defendant's evidentiary challenge is wholly unreviewable. In any event, on this record, we cannot say that the trial court's preclusion of that evidence was an improper exercise of discretion. On the contrary, it clearly was a proper exercise of discretion, as the only possible purpose for the statement was a hearsay purpose.
Now, even if it were hearsay, would the defendant be entitled to introduce it if that is the only manner in which he can assert his defense?
Your Honor,
And say defendant is entitled to assert a defense.
yes, of course, a defendant does certainly have a constitutional right to present a defense. And even under that analysis, first of all, that issue is completely unpreserved. But for that kind of evidence to come in under that standard, you have to have some kind of indicia of reliability, and you have to be able to assess the statement's materiality and the extent to which it exculpates the defendant. Because we don't know what the statement was at all, we can't do any of that. But
Well, the people know because they were part of the ex parte application for this statement.
presumably the trial prosecutor does know.
Yes.
But
And I'm sure he shared that with you.
No, Your Honor. In any event, the indicia of reliability of that statement is extremely low. It's a statement from his brother that took place after.
Does it go to the state of mind? Would that exception apply?
Your Honor, it doesn't apply. It doesn't go to the state of mind exception. I think the most common use of that exception is when there's an issue as to whether or not defendant performed an act, as I believe the panel was alluding to earlier. We know exactly what happened when defendant went upstairs, so there's no issue. There's really no dispute of facts as to what occurred at apartment 7C.
But that doesn't tell us that that was his intent, right? We know that he intended to go upstairs, right? Presumably, he would go upstairs to the same place he just came from, the party. So, playing devil's advocate, it absolutely goes to his state of mind. If after attempting to leave with his brother, he has a change of heart for whatever reason and decides to go back up in the elevator, one might absolutely and quite justifiably speculate that he's going back upstairs to the party.
And that's exactly what it is, sheer speculation. We have no idea what the statement was. And I think really the hearsay purpose is laid bare by counsel's statement on the record that it simply would have shown his non-criminal intent. If the issue goes to his intent.
So is that another way of saying what his state of mind was? If he has no intent, then it goes to his state of mind. So was that not then an appropriate application for a hearsay exception?
I don't think so, Your Honor. And a couple things to that. First, I'd like to point out that the cases that my adversary was discussing, in particular, I believe it was the Boiling case, I think that case really shows why the hearsay exception, that particular exception doesn't apply here. I believe the statements in question in that case were something along the lines of, let's throw something out the window. Of course, that doesn't go to the truth of the matter of whether or not those things were thrown out the window, but it goes to defendant's state of mind. If defendant says, I'm going back up to my friend's party, that the only use for that can be the truth of the matter that he believed he was going back upstairs to the party. And again, as you...
But it goes to the state of mind that he intended to go to the party, not to some random apartment, which is where he ended up, 9 floors below where he intended to go. So why is that not appropriate state of mind evidence?
I don't think it is appropriate state of mind evidence because, again, I think the state of mind exception really is intended for circumstances where acts and occurrences in particular are an issue, not really like a defendant's intent. But even setting that aside, even if he said, I'm going back up to my friend's party. When he arrived there, he wouldn't start banging on the door and immediately punch whoever opened the door in the face. I think that's still, even if it were a mistake of fact scenario, he's still guilty of burglary in the first degree. And as I'm sure the panel is aware, his actions were horrendous. He caused the woman who opened the door severe injury to her eye. Even at the time of trial, she still said she had issues with her eye and had to take drops and had some inflammation. So it wasn't completely even resolved by then. But even more so than that, the emotional trauma of the event was prolonged. The victim described for the sentencing court how she suffered from PTSD. She couldn't sleep in her bedroom. She slept out on the couch because she wanted to watch the door. Even when someone knocked on the door, the events of that evening would come rushing back to her. So the jury, of course, the jury didn't hear the victim impact statement, but the jury heard a lot of the evidence of this horrendous crime, and it heard all the evidence of defendant's intoxication, and unquestionably the people proved defendant's guilt beyond a reasonable doubt. There's a few other points in the brief. If Your Honors have any questions, I'd be happy to answer those. In that case, we ask that you affirm. Thank you.
Thank you. Counsel, you have 2 minutes.
Thank you, Your Honor. Just briefly on the hearsay issue. First, the issue of whether this is hearsay is a legal question that this court reviews de novo. It's not a question of discretion here. And as respondent pointed out, we know what happened next. He ended up on the 7th floor, and that's why this statement was not going to the truth of the matter asserted, because he ultimately ended up on the 7th floor, but excluding the statement, the most contemporaneous statement in the minutes before the incident of, as counsel explained, explaining why he returned upstairs, that was crucial in this case. To respondent's point, if he had gone up to this party, why would he punch someone? Well, that is based on respondent's theory and shows the implausibility of this theory.
Does the fact that the defendant, together with 2 of his friends, not sure which 2 they were, returned to the apartment and were banging on the door so loudly that a neighbor and the occupants of the apartment stayed inside until the police came?
Your Honor, the testimony...
And how does that impact this whole scenario?
Absolutely, Your Honor. The testimony was that after being pushed out, Mr. Cruz kept banging on the door and asking to know what had happened, why had the occupants inside hit him, and he repeated that statement, "Why did they hit me?" as he had blood gushing down his face from the hammer that had been swung at him. And when he said that he was going to bring his friends to retaliate, that actually further indicates that he was confused, that he had believed that he had just been attacked. And that does not diminish the seriousness of this incident and of his actions, but it further supports the notion that he did not know that he was breaking and entering. He did not have the requisite knowledge or intent to commit this offense. And that also goes to the fact that the prosecution failed to prove knowledge here. And just to make a very brief statement
I will
regarding—
give you 30 seconds because you're out of time, but
Thank
I'll
you,
give
Your
you
Honor.
30 seconds.
Thank you, I appreciate Your Honor. Just with regard to sentencing, there was extraordinary advocacy here by Riker's staff before sentencing, asking for leniency based on Mr. Cruz's commitment to rehabilitation and his understanding of the impact that his serious alcohol addiction has had on his actions. And this court can be certain that he will continue on this rehabilitative path.
Thank you.
Thank you.
And I want to thank you and your firm for taking this case pro bono on behalf of the court. We appreciate that, and we appreciate you both today.
Thank you, Your Honor.
Lazar versus Moore.
She was good.
You may proceed.
Good afternoon, Your Honors. Joseph Tripodi on behalf of the appellant. The trial court found that the appellants were put on notice of defendant respondents' fraudulent activities involving the LSCs and their purchase of the properties by March 2017 at the latest. That was based on two questions that my clients had raised, none of which had anything to do with the purchase price of the properties.
But wasn't it also based upon, in addition to the questions, the fact that this was publicly available information that could have been gotten from the ACRA system?
Well, the lower court
As of March 17, 2017, or, you know, the purchase price?
that I don't know if the lower court relied on that in particular in finding that they were on inquiry notice at that point. I think the reading is that the court found that they were on inquiry notice as of March 17th, and they could have easily found the fraud through ACRA.
The court pointed this out in its decision, that the information with regard to the purchase price was publicly available, and therefore your clients had an obligation to exercise their own due diligence.
It was publicly available, but there was no indication at all, factually. There's nothing in the record that they had, that there was anything improper
counsel,
about the purchase price.
If that's the case, why in March of 2017, wasn't there a request for the closing documents? Why would you want the closing documents if you didn't believe that there was some issues with?
Because my clients believe that the defendants never funded, never put their capital contributions in. My clients were looking for
Closing documents, counsel, closing documents, closing documents.
Yes, closing documents.
Closing documents, i.e. how much was paid for the buildings, et cetera, et cetera. That's what you were asking for, correct?
Yeah, it would include
Oh, doesn't that
closing
suggest
statements.
you're on notice? Doesn't that suggest that you're on notice as of March 2017, that there's some issues with respect to the closing, and as has been brought out, easy opportunity to resolve that by looking on the ACRA system?
The ACRA system does not provide, it provides the deeds, the recordings, but it doesn't provide the closing, attorney
It
closing.
certainly provides the purchase price,
It does provide the purchase
so
price.
that your clients, had they done that de minimis act of checking ACRAs, would have known and then would have been able to timely file on this issue.
No question about that, Your Honor. Okay. Absolutely no question about it. The thing is, were they on notice of the purchase price? Inquiry notice.
Look, if I have a concern that as to one issue on a deal, my partners are not being 100% upfront, as far as I'm concerned, everything is up for debate.
Your Honor,
and I should check everything. I want to check the I's, I want to check where the T's are crossed, and where are the periods.
If
That's
that,
how much I want to check.
Your Honor, if that's the rule in this court, we lose.
No, it's not a question of whether the courts have been very clear that a sophisticated party has an obligation to its own self-help. Your client didn't avail itself of what was available to him.
The purchase price paid would not have answered the two questions that my clients were seeking.
It would have told you you had a bigger problem.
It would have, but it's
Right?
absolutely, Your
Okay.
Honor. That's not a debate. The question is, were they on inquiry notice as to the purchase price fraud? There were other problems, yes. And if Your Honor indicated, they should have checked everything. Absolutely.
Counsel,
The
your
entire
clients were checking figures as small as $2,000. So if you're gonna check that bills were paid and credited without any kind of documentation of why that money was spent over there, why on earth would you not check to make sure that the right amount of funds are being put forth by all of the parties in the transaction?
Again, Your Honor, the answer, this was a 4-year relationship. There were a total of 5 properties. There were tens of thousands of emails exchanged. There were a number of issues, but the 2 questions that were raised were very specific questions that had nothing to do with the purchase price. So if those 2 questions, which had nothing to do with the purchase price, placed my client on inquiry notice that there was a problem with the purchase price from 5 years earlier.
Would you say that those 2 questions put at the heart of the relationship whether there could be complete trust between these parties?
Agreed, Your Honor. I would agree
Okay.
that there was distrust, yes.
Okay, all right, you'll have time on rebuttal.
Thank you.
Good afternoon, Your Honors. Andrew Goldenberg for respondents Arik Moore and Uriel Sacron. Judge Manzanet, you're right. This was a de minimis act that could have been done. They could have checked ACRIS to figure out what the purchase prices were. And look, you can look at their complaint. What are they alleging? They're alleging that there were fraudulent activities as early as August or September
And there
2016.
were. The problem for them is that they didn't find them out fast enough. They didn't pursue them fast enough because your client does not come to this court with clean hands, counsel.
Your Honor.
Your client lied. Your client said that the purchase price was over and above what it actually was and took from their partners enough money so that they would not have any money in the deal. Okay, so your client doesn't come to this court with any good grace. You may be right on the law, they slept, and you may win, but it's not because your clients did no wrong here.
Well, respectfully, Your Honor, I disagree with that statement.
I'm sure you do.
And if I may explain why.
Please.
Just for background, this case involves an investment in multiple multifamily properties in Harlem. The defendants, they found the properties, they personally signed and guaranteed
It doesn't
loans.
matter.
does, Your
They
Honor.
entered into agreements that each of the parties were supposed to put in equal shares into the property, no?
No, Your Honor. When the defendants sourced the properties, guaranteed the loans, found the attorneys, found the accountants, put together the financing, there's a premium that's attached that when an outside investor wants to come in and purchase interest, this was discussed in an earlier argument, membership interest in LLCs. So it's not that they're purchasing based on the purchase price of the property, they're purchasing to have the opportunity to make a good return on their investment, which, by the way, they did. Within 4 years of purchasing these properties, they made almost 100% return on their investment. That's a good return. So
And I'm
no
sure
one
your
was defrauded
clients did
here.
too without putting any skin in the game.
Your Honor,
Right?
you don't have to put
Counsel,
dollar for
I am more familiar with this process than you'd like to think, okay? So I don't need a lesson on real estate deals in New York City?
I'm not trying to give you a lesson,
Okay,
Your Honor.
I thought you were, but it's okay, go ahead.
I wasn't, Your Honor, but sorry about that. So in the complaint, just to point out, they're alleging serious concerns concerning the accuracy of the tax returns, serious concerns regarding the true sources of the capital contributions. What do the capital contributions go to? Judge Singh said it. It goes to the purchase of these properties. Okay? So at that point in time, 2 years before more than 2 years before they filed this complaint, they had an inquiry notice to do some sort of reasonable, diligent search, right? And that involved just going on a computer, checking accuracy. It does give you more information than just the purchase price.
Did your clients cooperate with the request for information? Or was that yet another layer of their obfuscation?
Well, I wouldn't call it obfuscation. I would call it a complicated relationship among 4 individuals that had a kind of a tortured history to it that went on for several years. And so at the point where they were looking to look into the books and records, that costs money. There was an argument about who's going to pay the accountant.
Aren't they entitled to, as partners, to look at the books and records?
They are, Your Honor, and the operating agreement requires anyone who wants to inspect to pay for it, and they refuse to. And so that's part of the issues that came about here. So it's not as simple, straightforward as, they refused, or they obfuscated, or they didn't make their investment, or they were hiding something. But for purposes of what we're talking about right now, we're talking about fraud claims that are time-barred because a reasonable investigation wasn't done. And this is the standard, and I don't have to say it, but the inquiry notice, it arises where the circumstances are such as to suggest to a person of ordinary intelligence the probability that he has been defrauded. So if someone shuts their eyes to facts, then the fraud will be imputed on him, the knowledge of it. And that's what happened here. The plaintiffs decided to shut their eyes to facts which, based on their allegations, not facts, their allegations, called for an investigation and potential fraud. And I just want to briefly cite the case that we mentioned in our brief. This court ruled on almost identical facts, the Mizrahi case from last year. It involved a plaintiff who alleged that the defendant offered him a piece in a commercial property based on a purchase agreement, and the plaintiff said, well, the purchase price that you told me was inflated, and this court said, well, he could have looked to ACRIS, time barred. Thank you.
Thank you. Counsel, you have 2 minutes.
I just want to address the diligence. My client did not sit on their hands. They retained their own accountant. When the company's accountant said that he couldn't put together the records, he needed more money, they went and hired a law firm to file a separate action in New York County to compel the accountants to produce the documents at great expense. A preliminary injunction was entered because they were clearly, as co-managing partners of the entities, were clearly entitled to the documents. Once they got the documents and saw that these closing summaries were in there, not the actual attorney closing statements, they filed suit. Then they continued. They went to the real estate council to get the real estate documents. They directed, the defendants directed real estate counsel not to give them the records.
But you know, that's all good and well. That's all good and well what you're saying. But as your adversary points out, simple enough. Go to ACRIS and take a look. I mean, that's what it comes down to, doesn't it? Ultimately?
There's no dispute, Your Honor. There's no dispute, but they did not sit on their hands because they were not focused.
Well, they were doing different things. They were pursuing different avenues, but our case law is pretty clear, right, about with respect to what the obligations are with respect to publicly available records, no?
But when if the rule is once it's on ACRIS, then you're on notice, then we lose. And with that,
well, no, that's not, no. The rule is a lot more subtle. The question is, when were you on inquiry notice that you should have looked? And it's hard to see why, as of March 2017, you wouldn't be based on the kind of information you're requesting, based on the allegations in your complaint, that a reasonable person would have looked, no?
Again, it was about capital contributions that had nothing to do with the price. It was about, did you put your money into the deal? Or did you not? It's not how much was the deal. It was completely, it's apples and oranges. That's the issue in this case. If notice as to an apple
it wasn't
is
counsel.
an orange, then it is.
It wasn't just how much money. You were looking at taxes. You were looking at the entire transaction. And you can't parse it out to say that I wanted to look at 99% of it and couldn't get the documents, but the 1% that I didn't look at, am not held responsible for. That's not what you pled in your complaint. You pled in your complaint that you were looking at the entire deal, about the tax consequences, about the tax returns, about the contributions. It wasn't just you were looking at one little tiny sliver and the whole rest of it was where the fraud was. That's just not what you pled, and not what if that was what you pled, much more of your complaint would have been dismissed. But you didn't. You pled that you were looking at the entire transaction.
Thank you.
Thank you, Your Honor.
And last but not least, Ellen Bogan versus Matrisky. You may proceed.
Good afternoon, Your Honors. May it please the Court, Benjamin Katz on behalf of the appellant, Michael Ellenbogen. The main issue here, Your Honors, has to do with the Court's consideration of the contractual agreement between the parties and the failure of the Court to consider that agreement in making its determination.
Do we consider the interests of the animal in this instance as well in making that decision?
Absolutely, and the Court did do that, and the Court indicated that that was the basis for coming to its determination. But this is a very arbitrary standard to apply. And
what's the standard? Should be a straight contractual standard and not consideration of the animal?
Well, consideration of the animal is always a concern. It should always be considered, but not above all else. It should be considered part and parcel of an overall review of all of the information here. And when appropriate, you should deviate from the standard that is established by precedent in cases where there's recovery of chattel.
As I understand the record, both parties contributed essentially equally to looking after care of the dog. So based on that, the consideration of the animal, the fact that both sides paid about the same, I guess, how do you say that what the Court did here was error?
Well, so you said it yourself, all things were pretty much equal here. The parties provided equally for the benefit of the animal. Both of them had places and could offer a life to the animal that was for the most part equal. So what was the determinative factor? What tipped the scales in this?
Well, I old and couldn't travel anymore.
I mean, things change.
The Court was very explicit in its decision that the animal was older, and because the animal was older, it was not the best interest for the animal to keep traveling back and forth. The Court was very clear in articulating why it made the decision it made. So why would we set aside the Court's determination of having a hearing after hearing all the testimony and making a decision?
Well, the Court did not have to address the continued travel of the animal one way or another.
Why not?
Because ultimately...
You are putting a 13-year-old dog on a plane every other month. That is not good for a 13-year-old dog.
That's correct, Your Honor, and...
So we should ignore that?
Not at all. Not at all. However...
You said that that was a consideration that the Court should not have weighed so heavily.
No, Your Honor, what I'm saying here is that ultimately, if the Court decided one way or another, there would be no travel. If the Court decided that possession would go to my client, it would be final. There would be no reason to travel back to New York.
Counsel, doesn't one side have to win and one side have to lose?
That is
I mean,
correct.
That's always the nature of this. If the Court decides that it's not good for this dog to travel, the Court has to decide who gets the dog, and that's within the Court's deference to make that determination, considering all the factors, which this Court obviously did.
Right. Well, the question is, did the Court consider all of the factors, including the agreement?
Well, what did the Court not consider? I mean, I mean, it seemed to me that the Court thought this through, said, yes, you live in someplace outside, and you have a nice backyard, but the dog has spent his whole life in her whole life in New York City, and the defendant has given her a good home and takes good care of her, and she has parks to go to and things, and she considered that. It wasn't an easy decision. It wasn't a slam dunk decision. She seemed to consider all the factors that you were the only two that testified. She listened to both of you, and this is what, I mean, not you, but your client.
I understand, Your Honor.
And this is what she figured. So she put, what did she weigh incorrectly? Since, well, of course, we have to give deference to the trier of fact.
Sure. Well, just minor correction. It was a male judge, so it was the.
Sorry.
It's okay. But he should have considered as I mentioned, he should have given some consideration to the contractual arrangement. Now, you mentioned about travel. My client had indicated that he was more than willing to drive if necessary rather than plane, but obviously there's issues involved with driving across the country as well. So I'm not going to necessarily say that. Ultimately, the court was put in a position where it had to decide the ultimate status, and it had to be exclusive possession to one or the other. Our argument here is that it should have been in favor of my client since a breach occurred on behalf of the respondent. Equity should have favored.
Counsel, so again, your argument essentially is that primarily what we look to see whether there's a breach of contract here.
I think that a breach of contract.
The dog is chattel, based on that analysis, and you look at breach of contract, and that's the end of it. I would submit to you that the law, the Raymond case, for example, doesn't support that position.
And we can discuss that on your rebuttal time since we doubled your argument.
Thank you, Your Honor.
You may proceed.
Hi, I'm Melissa Matreski, pro se. Okay. In terms of the argument, in terms of the best of all concerned, in actuality, I paid majority of the vet bills. What the other party, he actually paid the veterinary health insurance and claimed on the money I paid. He claimed insurance money on that, and he's also indicated that at times. So it was as if I would pay the bills, he would collect the money, even though he paid the insurance. Aside from that fact, I had taken her to majority of all the vet bills. When the lawyer...
Relax.
Sorry, okay.
Just relax. Tell us your story. Just relax.
Why don't you tell us about the dog?
Yeah, she's amazing. Sorry.
It's okay. Just relax.
I've never done this before.
That's quite all right. Tell me why this dog should stay with you.
I've taken care of her whole life. On top of that, I do make sure she goes to every single vet. The vet is located in New York, not one in Tennessee. If he did take her in one in Tennessee, it was because she was playing in the backyard and got a tick. That was the only time it was taken from Tennessee. Other than that fact pattern, I care for her. I give her everything she needs. If they're talking about the contractual agreement, it was actually the other party who changed it from monthly to bi-monthly. And then when he was continuing during COVID, he had mentioned he wanted to receive Lila, but he never gave a return. And each time, it started in March, June. June, he could return back. He could have came. He did not give a return date. He did not come back. It was in September. He then says, I want to come back in November. It was all on his terms. He only wants the dog on his terms, and only when he can collect. And during that period of time, I paid for the vet bill, and he acknowledged that he got the claim of the money. I didn't ask for that in return. All I'm asking is I want this to stop.
Okay. Thank you so much.
Thank you.
You have 2 minutes, sir. And I'm going to hold you to that.
I understand, Your Honor.
Okay.
So, Your Honor, obviously, the respondent makes a very emotional appeal to this court, as she did to the lower court. I'm not saying that this should be a breach of contract action. I'm just saying that the contract should have been considered at the time by the lower court.
I would submit to you that it was considered, and ultimately the court decided that since the sums were about the same, that other interests should be considered in determining who gets the dog.
Well, I'm limited to what the court indicated on the record and in its written decision and order, and it didn't indicate anything about the contract or the agreement of the parties.
I mean, the standard that it seemed everybody agreed to, I mean, both sides and the court, was best for all concerned standard. So that takes everybody into account, your client, the defendant, and the dog. I think that's what the court tried to do. I mean, you know, Solomon had a different suggestion. I don't think we want to suggest that here. That was a long time ago. But these are very difficult decisions, and I think it would be wrong to say that the trial judge who heard all this testimony did not take all of that into and consider the best for all concerned standard, which is what everybody agreed the standard should be.
Well, Your Honor, I understand, but it does, this standard, without considering anything else, does lead to arbitrary decisions by the lower court.
But
and
I'm sorry, counsel, how is it an arbitrary decision when you got an elderly dog, it's a large dog, 13-year-old, so life expectancy not as long as maybe a smaller dog? Wasn't that all taken into consideration when the court determined that it was best interest of the dog and everybody to keep the dog in New York and not uproot the dog?
Again, the parties had a situation where the dog was spending equal time in both places. So to say that the home was in New York is not necessarily the case here. It was equally in both places. So it was basically a resident of both states. I'm just...
At the end of the day, there was a request to decide with which party this dog should reside permanently. And the court considered both sides and made a determination. We've heard your arguments. Thank you both. Have a good evening. This court stands adjourned.
Thank you, Your Honors. Thank you.